fiduciary control, legal personality, and remedies in forum strategy. Intro. You confront a hard boundary between continual guidance and personal execution. The thesis you evaluate is that progress requires you to transition from passive reception to active, document-driven action. The animating claim is simple. As long as you expect others to supply steps, you remain on a procedural treadmill. Once you assume authorship of filings and records, you create legal leverage. The immediate implication is a shift in posture. You stop seeking more explanations and begin building a record that compels recognition of your status, rights, and remedies. In this frame, the closing of external instruction is not abandonment, it is a forcing function that places the burden of proof, and the opportunity for control, on you. Footnote. This section frames the project as a transition from dependence on outside instruction to personal authorship of legal action. Fiduciary form. You are told that many officials operate behind the veil of name-only capacity, insulated by color of law formalism. To pierce that veil, you are urged to give a body to the name by filing Form 56, Notice Concerning Fiduciary Relationship, and assigning duties to the officeholder as a fiduciary. The biblical analogy offered is the Levites, who received offerings and removed usury before returning cleansed property. Translated to modern process, you would instruct the designated fiduciary to administer and return assets free of unlawful encumbrances. The linguistic gloss asserts that fid denotes untangling, and shieri connotes an operative use of that tool, hence, a mandate to unwind complexity and restore substance over form. Footnote. This section presents Form 56 as a device to transform a name-only role into a duty-bound fiduciary tasked with unwinding encumbrances. Fiduciary assignment. You are advised to treat the assignment as an exercise of mastery rather than supplication. By issuing the Form 56, you purport to convert a general fiduciary into your specifically assigned fiduciary for a defined task. The claimed consequence is jurisdictional. Once assigned, the official is stripped of purely color of law protections and becomes accountable under black and white duties. In this model, you act as principal, the state actor becomes agent, and the scope of obligation is fixed by the text of the assignment. The strategic object is twofold. First, to create a paper trail that grounds later remedies. Second, to recast the relationship as service to the property owner rather than dominion over the person. Footnote. This section describes the Form 56 assignment as a principal-agent realignment designed to impose concrete duties on officials. Protections. You are instructed to anticipate noncompliance and to preposition remedies. If the assignee fails to act, you file judicial conduct complaints and, where warranted, criminal complaints premised on breach of fiduciary obligation. The asserted gap in past efforts was one-sided accounting. Filers did not connect government certificates, licenses, and other instruments to the insurance and settlement mechanisms that purportedly enable return of rents and other proceeds. Your corrected approach pairs the fiduciary assignment with claims administration, so that utilities, taxes, and similar exactions are processed to settlement rather than left as open liabilities. The practical emphasis is evidence. You preserve copies, lodge them in the court record, and thereby establish service, notice, and default. Footnote. This section urges you to pair fiduciary assignments with complaint pathways and a documented claims record to cure past one-sided filings. Leases. You are asked to analyze historical creditor claims that allegedly survived major conflicts and restructurings, including the Civil War and later fiscal arrangements. The narrative contends that ecclesiastical creditors acquired leasing rights against national treasuries with 21-year horizons, renewed across wars and reorganizations, and that individualized independent treasury accounts later attached to each recorded birth as a state of land interest. On that premise, you are told to issue fiduciary notices to diocesan offices to obtain releases of any residual leases that encumber your account. The central technique remains constant. You use Form 56 to identify the fiduciary, define the duty, and demand the documented release. Footnote. This section advances a historical lease theory and directs you to seek written releases via fiduciary notices to remove alleged encumbrances. Drawbacks. You are cautioned against commodity monism and invited to reconceive money as a basket of exchangeable commodities originating in America, not solely specie. The operative maxim is diversification. You do not concentrate risk in a single store of value, instead, you hold multiple commodity forms and convert selectively to meet needs. In this view, fixation on gold and silver narrows strategy and increases volatility exposure. Your task is to map where your claims clear, what instruments settle which liabilities, and how to time conversions for utility rather than symbolism. The law and economics point is that optionality and liquidity dominate ideology when you bear the execution risk. Footnote. This section warns you away from single asset ideology and centers diversification and liquidity across commodity forms. Exchangement. You are pointed toward a settlement pathway framed as lawful exchangement. After you establish your record, fiduciary appointments, lease releases, and court filings, you would approach the Treasury interface through a qualified commodity broker to convert assets into usable media of exchange. The step is deliberately high level. You are expected to infer venue and sequence once you have secured your documentary footing and cleared encumbrances. The operational thesis is simple. Without a clean record, you lack standing to demand settlement. With a clean record, you can instruct professionals to process conversions while preserving audit trails. Footnote. This section posits that, once your documentary record is perfected, you use intermediaries to convert claims into spendable value. Conclusion. You now own the next step. The instruction stream ceases, the evidentiary record begins. Your success turns on disciplined drafting, impeccable service, and careful archiving. If you proceed as principal, not petitioner, and you measure progress by documents filed, notices perfected, and releases obtained. If you decline, the opportunity cost is yours. The closing admonition is austere but clear. Execute the plan or accept the default. Either way, the record you build, or fail to build, will govern your remedies. Footnote. This section closes by assigning you full responsibility for execution, emphasizing records, service, and measurable outcomes.